Thank you, Anna, and welcome to all to our webinar on maximizing IP value at the crossroads of protection and tax planning. I'm Jim Ferguson. I am an IP litigator based in Chicago, and I'm joined by my partner, Mike Lebovitz, who is the co-head of our international tax group, and Mike is based in Los Angeles. If we can go to the next slide, I want to give an overview of what we're looking at today. And in broad strokes, we're going to be talking about both the tax and the IP issues that surround any movement of intellectual property. We'll first focus on the importance of intellectual property in tax planning. With that background, we'll give a survey of recent global tax developments, and then turn to legal risks associated with IP movement. Our next topic will be transfer pricing risks associated with IP movement. And we will conclude with what will become the major theme of this presentation, and that is the importance of collaboration in IP tax planning. And what we're really focused on is collaboration between the tax lawyers and the IP lawyers, because as we'll see, there are important IP risks and important tax risks that are implicated anytime intellectual property is moved. And in order to adequately protect a company's interest without compromising both its tax concerns and its IP concerns, the IP lawyers and the tax lawyers have to be talking to one another. So with that broad background, I'm going to turn the floor over to Mike to discuss our next topic. Mike?
Great. It's always interesting when we start a discussion like this, we start with tax, because oftentimes tax is the driver with respect to IP planning, and we'll touch on that. But just some of the issues or some of the attributes of IP lend itself to focusing on tax. So first of all, at the outset, IP is usually the crown jewel asset of a company, the basket of IP, not just registered IP, patents, trademarks, etc., but all of the intangible property, intellectual property that comprises sort of the know-how of a company. That's all generally always the crown jewel asset of a company. So we're going to touch we're going to talk briefly about why that is and why that makes tax planning so relevant. As Jim mentioned, because IP is inherently mobile, it can be moved. We can't just pick up a plant and move it to another country. We can't just easily relocate our supply chain. We can do that, but there are physical movements of goods, etc. Moving IP just by its various nature is easier, and as a result, it creates numerous tax risks. We're going to spend a little time talking about some of the differences between legal and economic ownership, and when we might move legal ownership versus just the economic rights to the IP. And we'll spend a little time talking about some of the nuances around exclusive versus non-exclusive licenses, why that's relevant from a tax standpoint, and why that's particularly relevant for an IP from an IP standpoint. And again, to continue the theme, is hopefully what you'll see at the end of our discussion is that coordination between tax and IP is critical. The worst thing that can happen is we put together a tax structure that moves IP, but limits the enforcement or the ability of a party to enforce IP, either a patent, trademark, etc. The worst thing we can do is move an asset for tax purposes and not be able to enforce the validity of that IP from a legal standpoint. So next slide. So as I said, by its very nature, IP is easy to relocate. because at the end of the day, IP rights are generally driven by contractual rights or by registrations. They're intangible, so they are easy to relocate. And from a tax planning standpoint, at its very core, because IP is easy to move, then the objectives often are trying to isolate and value that intellectual property, and then historically transfer that IP to a low tax jurisdiction at a minimal tax cost. Now, it used to be a lot easier to move IP out of a country somewhere else to a lower tax jurisdiction. Most countries, the US and most developing countries, limit that by imposing tax when IP is leaving the country. And in the US and in many countries around the world, that taxable transaction when IP is moving cross borders, that is the most significant tax issue in disputes working their way through the IRS, through the tax courts, are all driven around an outbound transfer of IP. And it's easy to see some of the industries where IP is critical: life sciences, technology, fintech, logistics, you name it. IP is generally the biggest single profit driver in the profit spectrum of a company. Next slide, please. And so let's look here. And we're not going to. This isn't going to be a technical tax discussion, but what I'd like you to get out of this slide is the importance of IP as a value driver. So here we have a company that's got, sales, manufacturing, a headquarters function, and IP. And we've just posited here that the IP value drives half of the total value of profit. And I would submit that that's probably on the low end, depending on the industry. That's probably on the low end of a ratio. In some industries, in life sciences in particular, in technology, and in software development, IP could be 70-80% of the value of what's driving overall profitability. But if we start with that ratio, we can then hypothesize what a tax rate should look like. And so what we've done here is assumed a US headquartered company with a tax rate of 21%. We've ignored state taxes here. So just assume a 21% US rate. If we do no planning at all, the tax rate will end up, when you break it down according to these ratios here, the tax rate will be a little bit higher, will generally be a little bit higher than 21%, in part because more often than not, when you're selling in another country, if that country has a higher tax rate than the US, which a lot of countries do, then you're generally going to pay tax in that country as a result of selling in that country. So we've just assumed a 30% tax rate for sales. And so you get to a weighted tax rate of 22.8%. And that would be a benchmark if we weren't doing any planning at all. So let's then look at the next column, which is what we refer to as sort of the golden age of planning. This is the planning that was in place up through say 5 years ago, before this global agreement, a global minimum tax agreement, which we're going to talk about. In that environment, it was relatively easy to move IP to a very low tax jurisdiction. Could be 0, could be 10, depends on the jurisdiction. We've just assumed 5 here. And absent no other changes to the structure, as you can see here, the weighted effective tax rate drops considerably. And that illustrates the importance of IP in tax planning. And so there were numerous structures available under which a taxpayer, US or otherwise, could get a tax rate on IP in the low single digits. And there, as we'll see momentarily, that created a lot of headlines in terms of the amount of profit that companies had offshore in low tax jurisdictions. But all of that, as we'll reiterate in a minute, all of that was generally done by IP, through IP planning. And so we're going to talk about this global agreement in a minute. But what this global agreement has done is it has normalized the effective tax rate on profit to around 15%. So the 130, 140 countries, including the US, have agreed that all profit of a multinational should be taxed at least 15% somewhere. So if we applied that just to the IP, just keeping our same spread of profit drivers, you can see that there still is a benefit in moving IP offshore, but the benefit is significantly reduced relative to what it would have been before the global agreement and before some other developments that were designed to eliminate this low single-digit tax rate on IP. But you can sort of see the progression here. And again, the only change to the effective tax rate is just by virtue of moving IP to a different country. Next slide, please. So these are just sort of some of the headlines around that led up to the global agreement. And these are, these are not surprising headlines. They are all in the news. Many of you would have read about Apple's structure in Ireland. But many US and non-US multinationals had structures that enabled them to achieve very low rates of tax on IP-driven profits. And so there have been attacks over the last 10 years, culminating in this global agreement, that were designed to eliminate or reduce the benefit of this planning. And so what this global agreement is, just to reiterate here, is that this global agreement that, again, the US has signed on to, is that all profit of a multinational needs to get taxed at 15% by some country. The challenge here is the real challenge is once these 140 odd countries agreed to a 15% minimum rate, they then needed to agree, okay, well, if there is profit that's not taxed at 15%, who gets to tax that, who gets to top up? Who gets to tax that under-taxed profit first? And there are hundreds of pages of guidelines and regulations all designed to answer that question. But the short answer is that if you're planning or if you're thinking about moving IP somewhere because you've heard that Dubai has a 9% tax rate, that Hungary has a 9% tax rate, that Israel has all these great incentives for IP. All of those incentives are subject to and will be implicated by this global agreement. But the common denominator here in all of this is all of this planning is driven by IP. So next slide, please. So let's talk about the global agreement a little bit. And before we talk about the global agreement, we need to take one step back because before we had this 15% global agreement, and you may have heard of and this global agreement has been negotiated through the auspices of the OECD. And this global agreement is referred to as part of the OECD's BEPS initiative, BEPS, Base Erosion and Profit Shifting. The global agreement is essentially BEPS 2.0. BEPS 1.0, which came into being a couple of years ago, essentially set a new standard with respect to the taxation of IP profits. So if we accept at face value that IP generates premium profit, that's what really drives profitability of a company. What the world has agreed to is that if you're going to have a company that's going to own IP, in order for that company to earn premium profits associated with that IP, then that company better have sufficient substance to be entitled to earn those profits. And so the question then becomes, okay, well, what is substance? Let's say I want to move my IP to the Cayman Islands or Bermuda or somewhere. What kind of substance do I need? Well, it's a lot different than I got to have a couple of board meetings in Bermuda. I got to have one guy in Bermuda. That world has changed. The standard now is that you have to have sufficient substance in a jurisdiction where there are people employed there that are capable of exploiting that IP. They're charged with, there are people that have the authority to be involved in the development, the enhancement, the maintenance, the protection, and the exploitation of that IP. And so those words I just used, development, enhancement, maintenance, protection, and exploitation, that's DEMPE, that's DEMPE. And that is the standard that a company must meet in order to be entitled to earn premium profits. And so what that means is that absent some unusual circumstances, it's going to be highly unlikely that you're going to have that substance in the Cayman Islands, in Bermuda, in BVI. It's possible. And we do have clients that have that sufficient level of substance in the Cayman Islands, but it's unusual. What it generally means is that the places going forward that you're going to be looking at for housing IP are places that have low tax rates, but at the same time, you can get substance into that country to meet that standard. And so you're talking about Ireland, you're talking about the Netherlands, Switzerland, Luxembourg to a certain extent, Singapore, Hong Kong, places that your high value employees that are relevant to the IP are willing to go and work. What that also means is that to the extent that you are going to a country like Hungary, for example, Israel, other countries that have low tax rates or have reduced their tax rates in order to induce Dubai, who have reduced their tax rates in order to induce relocation of IP, the benefit of those incentives are going to be reduced in light of this global agreement. And so as you're thinking about where you're placing your IP, it's important to sort of baseline around an expectation of a 15% rate, even if you've got some country saying relocate your IP here because we've got a 9% rate. You know, for example, the Netherlands has a 9% rate on IP. The UK has a 10% rate on IP. All those incentives are going to be reduced in light of the global minimum tax. The two other points here that are relevant. One is that because of this global agreement, transfer pricing, which used to be generally a bilateral issue. You know, you've got two countries that are fighting over the same pool of profit. So I'm in the United States, I move my IP to Hungary. And, you know, and Hungary wants to maximize the amount of profit in Hungary, which is subject to a lower rate of tax. The US wants to argue that there's more value in the United States, taxed at 21%. And so there's a bilateral dispute between Hungary and the United States over who gets to tax that pool of profit. When we add the global agreement to the mix, that means that you're going to have another country that also has some skin in the game as to whether they should get a portion of that profit. So, for example, Korea, as it happens, is the furthest country along in implementing this global agreement. Well, under this global agreement, Korea has the right to tax the difference between Hungary's 9% and the agreed 15% global rate. And so Korea will take a back seat to the US in terms of whether the US gets to tax that under-taxed profit first. But Korea has a vested interest in the transfer pricing between the US and Hungary, which means that Korea now is going to have its nose under the tent in the transfer pricing dispute between the US and Hungary. And so that's why going forward, all tax disputes relating to IP will become multilateral. It's going to be messy because of how complicated the rules are implementing this global agreement. And I think the last point I will make is that we showed you, I had some of the headlines before, and there have been a lot of headlines around effective tax rates. And why isn't company X paying more tax? Why is company X not paying any tax? There's a lot of headlines around that, the financial press, the tax press, and it's easy, it's easy to write those articles. What's changing is that starting next year, there will be substantially increased transparency regarding the effective tax rates of multinationals. And the EU, Australia, and other countries have developed regulations to require public disclosure of the taxes paid by multinationals on a country-by-country basis. Right now, multinationals have to do that and report that country-by-country report to the IRS or their local tax authority. Starting next year, that's going to be public in the EU. And that is significant because that's going to make IP planning visible to the public and other stakeholders. So the IP planning is going to be more challenging as a result of the global minimum tax, and it's also going to be visible. So that shouldn't deter us from planning. And before I turn it over to Jim, I want to talk about a couple of structures that will set Jim up for the issues that we want to talk about. But there is still a benefit to doing IP planning. It's just going to be less advantageous than it was in the golden age, and it's going to be visible to the public, to the press, and all internal, external stakeholders. So next slide, please. Here, we're just going to put a structure in place that Jim will, the slides that Jim will go through will touch on these slides. Here, we've just got a simple structure. We've got a parent company that's the IP owner, does the R&D, and it licenses the IP to a regional subsidiary at a 15% tax rate. And that regional subsidiary sublicenses that IP around the world. That's one structure. And we go to the next slide. We go to the next slide. Here, what we've done is we have a parent company, and it has agreed with its US subsidiary to share in the cost of the development of IP. And it's entered into what we refer to as a cost sharing agreement. And so the parent company and the regional US sub are essentially co-owners of the IP, and they get the right to exploit that IP in their respective markets. So just a couple of different structures that we'll come back to as Jim walks through now. Now that we've done some planning, or we're thinking about some IP planning, what does that really mean from an IP standpoint? And can we do this planning and still maximize our IP protection? And with that, we'll switch it back to Jim.
Thanks so much, Mike. Let's move to the next slide. As Mike just explained, there are oftentimes significant tax advantages resulting from the movement of intellectual property. But these advantages can be implemented only if there is a patent licensing structure that accompanies it. In other words, every time a company moves intellectual property from one affiliate to another, there has to be a resulting modification of the patent licensing structure. And what I want to do now is to look at some of the intellectual property issues that arise primarily as a result of the patent licensing structures among affiliates that a company may implement. First thing we're going to do is just take a 30,000-foot survey of conventional patent licensing structures. Most of these are cross-border, but they don't have to be. First, we'll look at the structure for the sale of patented products. Then look at a standard structure for research and development. And then we'll look at a third scenario involving the acquisition of new intellectual property through, for example, the acquisition of a new company. And with that background, I then want to walk through some of the issues in patent enforcement that may arise if the licensing structure is not drafted and designed with input from the intellectual property lawyers. So let's move to the next slide. Standard patent licensing structure involving the sale of patented products. So in this scenario, we have a patent owning affiliate. For purposes of illustration, we've assumed this is in Ireland. The patent owning affiliate grants licenses to make and sell with territorial restrictions to manufacturing affiliates throughout the globe. And then each of the manufacturing affiliates sublicenses a patent right to sell the patented product to distribution affiliates in different parts of the globe. Very conventional structure. There's also a fairly conventional structure involving research and development, which is depicted in the next slide. So with respect to research and development, again, the goal here is the development of new innovations. It's not the sale of patented products. In this scenario, the patent owning affiliate, in one variation, grants a patent license to conduct R&D to a research affiliate. The research affiliate creates new innovations, new products that result in new patents. And then the company has to decide where will these new patents reside? One option, of course, is to have them assigned to the patent owning affiliate, but there may be business reasons why the company needs to or wants to assign the new patents to yet another affiliate. The second scenario involving R&D is research collaboration with a third party. Again, this is designed to generate new innovations, and so the patent owning affiliate may grant a patent license to a third party to conduct research that will result in new innovations, new patents. And the question is, who will own the new patents and the new innovation? That will be determined through the agreement with the research collaboration with a third party. Let's look at the third scenario, which is the acquisition of new intellectual property accompanying the acquisition of a new company. Can we move to the next slide, please? All right, so in this scenario, the parent acquires a new company that itself owns intellectual property. It owns patents. And so the parent acquires this new intellectual property. What does it do with it? Well, in one scenario, if the patents cover, for example, a new research platform, it may license the newly acquired patents to an affiliate engaged in R&D. And then that hopefully results in new innovations. Or if the new patents involve patented products, then it has to design a license to make and sell the products pursuant to the overall patent. I mentioned earlier that I'm a patent litigator, and I encountered these issues when, on 3 successive occasions, I was asked by a sophisticated multinational company to enforce the patents. And in each of these occasions, I had to tell the client that because of the way in which the licensing structure had been set up, it wasn't going to be able to fully enforce the patents. And we're going to get into those reasons. 2 of them involve licensing structures that had been put together by my tax colleagues. And the third involved this situation here, where the client had acquired a new company, it acquired new intellectual property, it acquired new patented products, but in the frenzy of the acquisition of the M&A, it neglected to design and implement a licensing structure, and this turned out to compromise the ability of the company to enforce its intellectual property. So let's look now at some of the issues that can arise from patent licensing structures in terms of enforcement. And there are 2 major issues. One is standing, and the second is the ability to fully recover damages in the form of lost profits, and in many cases, injunctions. Mike was emphasizing how intellectual property is the crown jewel of many companies. And indeed, it is central to the business model. And this often depends on the ability to exclude competitors from infringing the intellectual property, and that requires injunctions. So all of this is critically important, or can be critically important, to the business model of the companies. To explain some of these problems, I want to first give the background rules, which are set out in the next slide. These are US standing rules that I'm going to be talking about, standing for patents, but they're followed by many other jurisdictions, and they also apply in many cases to other forms of intellectual property, specifically including trademarks. Okay, what are the standing rules? First of all, the patent owner must be a plaintiff. An exclusive licensee can be a co-plaintiff. An exclusive distributor can be a co-plaintiff. A non-exclusive licensee cannot be a co-plaintiff. One of the big picture themes that emerges when you compare the tax world with the IP world is that the tax world is very focused on economic substance, whereas the IP world doesn't care that much about economic substance. It's focused on legal formality. Who owns the title, and is there an exclusive license in place? To illustrate, I want to give you a couple of cases. We can move to the next slide. Okay, here, no exclusive license if another sub has worldwide rights. In this case, the parent, the yellow box, was the patent owner. It brought an infringement action against a competitor to enforce the patent, and it wanted subsidiary number 2 to join as a co-plaintiff. And it claimed that subsidiary number 2 had an exclusive license in the US. The problem was that the parent had previously granted a non-exclusive worldwide license to another subsidiary. And the court held that subsidiary number 2 did not have standing because it was not an exclusive licensee. The prior grant of a non-exclusive worldwide license to subsidiary 1 meant that subsidiary 2 really did not have an exclusive license in the US. Two questions, or two issues, or two thoughts here. Why the emphasis on exclusivity for standing? The answer is that a patent right is a right to exclude, like any other form of property. It is a right to exclude. So in order to have standing to enforce the patent, you have to have the right to exclude others. If you have only a non-exclusive license, you do not have that right, and therefore you do not have standing. The other question that may arise from this scenario is, so what? So what if the parent could not join subsidiary number 2 as a co-plaintiff in the infringement action? The parent, after all, is the patent owner. It has standing to enforce the patent owner. To answer the so what question, let's turn to the next slide. No recovery of lost profits if the selling sub is a non-exclusive licensee. So in this case, the patent owner was the red oval, subsidiary number 1, and it had granted a non-exclusive license to subsidiary number 2, the selling affiliate. Subsidiary number 1 did not sell anything. Subsidiary number 2 was the seller. Subsidiary number 2 was the entity, therefore, that more directly suffered damage as a result of the infringer in the market infringing the patent. But subsidiary number 1 could not recover lost profits because it didn't sell the product. And subsidiary number 2 could not be a co-plaintiff because it was a non-exclusive licensee. So the bottom line, no recovery of lost profits. Yes, the parent could bring the infringement action, and yes, it could enforce the patent, but it could not, the subsidiary, the patent owner could bring the infringement action, but it could not recover lost profits. So a significant limitation on the damages that it could recover from the infringer.
So Jim, like, for example, just to compare between lost profits and everything else, I mean, what would sub 1's damages claim then be if it was not lost profits? What do they get? Cost recovery? I mean, what do they get?
They get a reasonable royalty. And as we'll see, there's another limitation on the relief they can get. They will not be able to get an injunction. So it's a severe limitation on the ability to fully enforce the patent and to fully recover the damages resulting from the infringement. I want to illustrate the same point with another case, which is depicted in the next slide. Okay, in this scenario, the parent is the patent owner. It brings an infringement action against the third-party infringer. Its wholly owned sub is the seller, but it had only a non-exclusive licensee. Now the parent argued to the court, give me a break. This is a wholly owned subsidiary. How can you possibly say that the profits that were lost by my wholly owned subsidiary don't entitle me to recover lost profits. The court rejected the claim because there was no non-exclusive license. Subsidiary one could not be a co-plaintiff, and the court noted that the parent had set up this corporate licensing structure for purposes that it deemed to be advantageous to itself, and it had to live with the good and the bad. So even though subsidiary number one was a wholly owned subsidiary, even though in the real world it lost profits, it could not participate in the litigation, and the parent therefore could not recover lost profits. And this is a really good illustration of the point I made earlier. The focus in the intellectual property law on legal formality as opposed to economic substance. What really drove the outcome of this case was the simple fact that there was not a non-exclusive license in place between the parent and the selling sub.
So Jim,
Sure.
Jim, does that mean, but can the parent here sue to recover lost profits?
I'm sorry, can the parent?
Could the parent, we know that the sub one can't be a plaintiff.
Correct.
And so what you're saying is that the parent's claim itself, it's not the sub's claim, it's the parent's claim that the parent doesn't get lost profits either.
Exactly. That's exactly right. And,
Yep.
and the parent was making a very compelling argument based on economic substance, but it didn't carry the day.
And I think the thing that's relevant here is, you know, that as hopefully you've gathered, the difference between exclusive and non-exclusive licenses is key from an IP perspective. But from a tax standpoint, the economics of it being an exclusive licensee or a non-exclusive licensee are different, and that changes the economics. And since so much of what we're doing from a tax planning standpoint with respect to IP is trying to allocate the economic benefit of IP, oftentimes we'll try to use exclusive or non-exclusive licenses to get the right tax result. And this is the importance of the interaction, because we could do that, and that all works until there's an infringement. You know, it's like the Mike Tyson story. Everybody has a plan until they get punched in the face. Well, we could put the best structure together, but if there's an infringement action, then that plan might go by the wayside.
I was explaining all of this to one of my clients, and I believe she pointed out that all of these issues, and therefore the critical importance of paying attention to these issues, flow from the fact that in order to enforce a patent, you have to engage in litigation, typically. And she referred to litigators, apparently forgetting to what I do for a living, as having evil little minds. And I think there was a grain of truth in that, because when you get in litigation, the opposing party is going to look for any possible angle it can find in order to attack the patent. And I can tell you that when I'm asked to defend against an infringement claim, one of the first things I want to get is the licensing structure of the opposing party, of the patent owner.
Hey, Jim, we had one question in the Q&A. We've been talking about patents. Does the same principle apply for trademarks?
The same principle, the answer is generally yes, but it depends on the jurisdiction. And in the US, for example, the same focus on the legal title holder is critical to determine whether or not an entity has standing to enforce a trademark. But it's jurisdiction dependent. Okay, let's look at the next slide, which involves injunction. I mentioned earlier how important injunctions are to many business models. And the cases have made clear that if the IP owner is not selling the product, it may not be able to obtain injunction. So if the infringement action involves a plaintiff that is only an IP owner, it's not selling, that the subsidiary that is selling does not have standing, it will be very difficult to show irreparable harm, which is a requirement not just in the US, but in many other jurisdictions for injunctive relief. Courts are often reluctant to award injunctive relief to entities that do not sell the patented product. Okay, so the takeaway from all of this is that the IP lawyers do not need to be at the head of the table. We recognize that many of these transactions are tax-driven because there are significant tax benefits to the company. We don't have to be at the head of the table, but we do have to have a seat at the table. And we can work with the business folks and with our tax colleagues in putting together a structure that makes sense from both an IP and a tax perspective. With that background, I wanted to look at another slide, which turns to a point that Mike had made earlier, and that is, in some circumstances, it will make sense from a tax perspective to transfer IP in a way that does not constitute a sale. And so in this scenario, our tax league colleagues told us they wanted to convey all economic and beneficial owners' interest in the patents to an affiliate. And they elected to do that through an exclusive license. And the goal was to ensure that the legal title remained with the patent owner, but at the same time, through this exclusive license, all economic and beneficial interest in the patents would be transferred, conveyed, contributed was the word, contribution, to the affiliate. So we recognize this, and we also recognize, we the IP lawyers recognize that in the IP world, an exclusive license can sometimes be deemed to be an assignment, i.e. a sale, if it effectively transfers all rights in the patent to the affiliate. And we were kind of worried by phrases like conveying all economic and beneficial interest in the patents. But under the IP law, we would be on safe ground if the patent owner retained some rights, such as the right to control infringement litigation or the right to control sublicenses. So we simply made a few amendments to the exclusive license that our tax colleagues had drafted to ensure that the patent owner would have sufficient retained rights in the patent, notwithstanding the fact that all economic and beneficial interest in the patent had been conveyed to the affiliate, that it would still be an exclusive license, it would not be a sale, and it therefore would not be a taxable event.
And it's important, sorry, go ahead, Jim.
No, I simply was going to cite this as a great illustration of how the tax and the IP lawyers can work hand in glove to achieve the desired result.
Well, and it's interesting because more often than not, when we are developing an IP structure, we want to move IP from the US or from the parent company to a subsidiary. And you know, we do that, or we start planning for that, and then Jim or the IP folks come in and say, well, we don't want to do that. We want to keep legal protection in the United States. We want to keep legal ownership in the United States. And so there are numerous structures where we have split legal and economic ownership, where legal ownership remains in one place and the economic ownership is moved elsewhere. And that generally if that generally accomplishes the tax result we need. The important point here is making sure that once we've done that, whether we have eliminated by just stripping everything out other than bare legal title, whether we have somehow compromised the ability of the legal owner to enforce the IP.
All good points. I want to turn finally to another issue that's related but different, and that is employment agreements. in any company that places a high value on intellectual property, employment agreements are going to be critical. As you may know, under US law, and this is true in most jurisdictions, an employment agreement can provide that the employee hereby assigns all future inventions, all future innovations, all future trademarks, excuse me, all future intellectual property to the company. And under the law, the assignment will take place at the moment that the employee conceives of the innovation. As a matter of law, that assignment takes place. And so it's point number one is it's very important for the employment agreements to include provisions in which the employee hereby assigns all future patentable inventions to the employer. A difficulty can arise, however, if the agreement defines the company to be the parent and all of its subsidiaries. From an HR perspective, that makes a lot of sense because in many cases, employees will move from one affiliate to another, and this will be a one-size-fits-all solution. The problem is that recognizing that the assignment is effective at the moment the invention comes into existence. The question is, if you define the company to be the parent and all of its subsidiaries, does that mean that the entire corporate structure, the affiliates, the parent, all of it, are each co-owners of the patented invention? This has become the subject of litigation already. Two potentially significant consequences if every affiliate in the company is a co-owner of the patent. First, under US patent law and the law in other jurisdictions, every one of those entities, because they are co-owners, would have to be a named plaintiff. That can get unwieldy. But even more concerning is the scenario in which the company subsequently spins off one of the affiliates, which would arguably still be a co-owner of what could be a critical patent in the company's portfolio, and now it would be an independent third party. So all of this underlines the importance of giving attention to employment agreements in order to ensure that the inventions are assigned to the proper affiliate.
And one other quick point here. So a question though, Jim, is that if the invention assignment agreement assigns the invention to the parent and all subsidiaries, so you said that means that the parent and all subsidiaries would need to join in a suit. What happens if you leave one of the subsidiaries out? Does that cause the entire complaint to fail?
No, there are rules that will allow the remaining plaintiffs to join the affiliate that does not join. You can even require a compulsory joinder. So I don't think that would pose a major problem. It would just be extremely unwieldy. Among other things, in this scenario, all of these affiliates would be subject to discovery,
right?
Because they're co-owners of the patent.
And I think the other point I wanted to make here is that this is people often overlook the tax issues here because this is generally an HR IP issue. But if you've got an agreement that is assigned, where the invention assignment agreement assigns the patent to a company, one of the companies, well, that company is going to be in a country somewhere. And now, from a tax standpoint, you now have IP that has come to rest in a country. And if that's inconsistent with what your overall tax plan is, then you might have some tax consequences in moving that invention from one company to another. Just because your invention assignment agreement said employee invented something, now it's owned here, now it's owned in a country, and we want to move it somewhere else.
Very good point, Mike, and I think that really reinforces the point of the need to give careful attention to these employee agreements to determine where the invention is going to reside. I think we're ready for our concluding thoughts.
So hopefully what you've gathered from this discussion here is that if you're doing IP planning, if you're doing tax planning for IP, the IP lawyers are involved. If you're doing IP, if you're planning for IP and you're talking to IP people, then tax people are involved. Because a failure to collaborate is significant, because I would say the failure is, okay, you might not achieve your tax objective.
And thanks so much for joining us in our webinar today.